Welcome to my channel. Please like, comment, and subscribe. Jones Act Employers and Medical Care Liability. The Jones Act covers a wide range of topics related to maritime law as a part of the former Mason-Marines Act. Part of the Jones Act includes employers' responsibilities and liability for accidents and injuries that occur to seamen in the service of a vessel. Just like land-based employers, sea-based employers have a duty of care to provide safe working environments that have minimal hazard. When an employer fails to provide this duty of care, it often leads to accident, personal injuries, and even death of the employees. On land, we refer to injury claims filed by injured employees as a workers' compensation at sea. We refer to injury claims filed by injured seamen as a Jones Act claims for injuries sustained on the job. Employers are required to pay for medical care and treatment. This is what is referred to a medical care liability. Failure to provide the necessary medical care and treatment can result in the employee seeking legal remedies with assistance from a qualified Jones Act attorney or workers' compensation lawyer. And then Jones Act versus workers' compensation. The Jones Act and workers' compensation have many similarities. They both provide medical payments for the care and treatment of on-the-job injuries. However, there are a few key differences you need to know. Does liability matter for workers' compensation claims? With workers' compensation claim, liability is not a factor to claim benefits. The employee could have been at fault for the injuries. The employer could be at fault for the employee's injuries. Both the employee and employer could have been contributed to employee's injuries. And then does liability matter for Jones Act claims? Liability in a Jones Act claims can matter when seeking compensation from an employer. Unlike workers' compensation claim, where liability does not matter to claim benefits, things are somewhat different with the Jones Act claims. The injured maritime worker must prove that the employer contributed in some manner to their injuries. The percentage the employer is at fault does not matter for filing a claim. For instance, the employer provided a faulty safety harness that led to the accident and subsequent injuries. Even if the worker was performing a dangerous task and not following the proper procedures, if part of the reason they were injured was due to the faulty safety harness, then they can file a claim. When an employee is found to have been partially at fault for the injuries, the amount of the compensation can be adjusted due to comparative negligence. This type of negligence is where a percentage is assigned to each party responsible for the accident and injuries, and a compensation recovered is then adjusted by the percentage amount the employer is found to have been at fault. To illustrate, let's assume that the employee was not found to be 100% at fault and the employer 90% at fault. The employee is entitled to a total of $100,000 in compensation. However, since they were 10% at fault, their total compensation received would only be $90,000, 100,000 until $10,000. Please note that these figures are just to illustrate how comparative negligence works and by no means should be used as a legal advice or how much compensation you could receive for your injuries. And then what compensation does the Jones Act cover that differs from workers' compensation? Another key difference between Jones Act claims and workers' compensation claims is the types of compensation one can recover. While both types of injury claims do provide compensation for medical care and treatment and disability payments, the Jones Act offers additional compensation, including lost wages. A seaman can claim past present and future lost wages due to the injuries, and then future medical bills. A seaman can seek compensation for ongoing and future medical care and treatment, such as surgery that is required due to the employer's or ongoing physical therapy. And then lost earnings capacity. The difference between what the seamen would have made if they could return to their former job compared to returning to work at a reduced earning capacity is another form of compensation allowed with the Jones Act claims. And then pain and suffering. An injured seaman can seek compensation for pain and suffering. And then physical disfiguration. If the injuries result in a loss of limb, scarring, or another type of disfiguration, the seaman can seek compensation. And then mental anguish. Compensation can be sought for mental anguish and suffering, such as depression, PTSD, or reduced life expectancy due to the life injuries. And then punitive damages. In some cases, the court will award the injured party punitive damages, which is an additional type of compensation at the court discretion. Injured seamen can also seek immediate relief for payable benefits provided by maintenance and cure. Another key part of a maritime law, and maintenance and cure does not require establishing who was at fault for the accident and injuries, just like workers' compensation claims. Maintenance provide payments for essential living expenses like food, housing, and basic utilities. Cure provides payment for medical care and treatment expenses. Injured seamen can file for maintenance and cure immediately following the accident. Additionally, if the injured seaman will not qualify for compensation under the Jones Act, they can still draw benefits through maintenance and cure. Yet, if they do have a grounds for compensation under the Jones Act, they can draw benefits through maintenance and cure as well as seek compensation with a Jones Act claim. And then how to qualify for Jones Act compensation. In order to qualify for Jones Act compensation, there are specific qualifications maritime workers must satisfy. Among these, the most important is that the workers must be in the service of the vessel at the time of the accidents and resulting injuries. Other qualifications include the seaman must spend a minimum of 30% of the time on the vessel. The seaman must perform work that contributes to the ship's overall operations. The vessel owner or employer must be negligent in some manner that resulted in the injuries. If you meet these requirements, then you could potentially have grounds for a filing Jones Act claim against the responsible party or parties. In such situation, there could be more than one responsible party that contributed to the accident and subsequent injuries. For example, a ship owner fails to maintain a seaworthy vessel that they have contracted out to other company. This company is the seaman's employer and is well aware that the vessel is not seaworthy, yet continues to operate it regardless. Since both the ship owner and employer demonstrated a lack of a duty of care for the seaman on board, if there is an accident that results in injuries, then the seaman could potentially sue both the ship owner and employer to compensation with the help from the Jones Act attorneys. Furthermore, one must file a Jones Act claim within 3 years from the date of the accident. Claims cannot be filed after his statute of limitation expires. Ideally, one would not want to wait until the last minute to file the claim, as there are sometimes delays and other issues that arise. Instead, it is highly recommended to file a Jones Act claim as soon as physically possible. And then, do I need a Jones Act attorney to file a Jones Act claims? While the law does allow individuals to represent themselves when filing a Jones Act claim, it is never a good idea to do so. Maritime laws are complex and detailed, with a wide array of exceptions. Additionally, there is a maritime case law, which could apply in a specific situation that one would not be aware of when representing themselves. Besides, self-representation frequently results in a much lower settlement than one is entitled to receive. The employer and the insurance company will have their own Jones Act lawyers protecting the interest to negotiate the lowest possible settlement. I think that's all, guys, the information that I can share to you. Thank you so much for watching. Don't forget to give a like, comment, and subscribe. Bye bye, guys.